Welcome back to Native American Studies 299, 499 here at Sitting Bull College, our Tribal Sovereignty and Contemporary Supreme Court Jurisprudence Special Topics Survey course. I'm your instructor, Kara Damari, and today we are looking at the 2017 U.S. Supreme Court case, Lewis versus Clarke. As always, we will go through the parties, the issues, the procedural posture, and the rule holding, and sprinkle in a variety of other information. And let's start off by looking at the parties. But before we get to the parties, let's bring us to the tribe we are looking at today. As this is a Native American Studies course, we tend to focus on the tribes, and let's look to which area we are in, and actually, let's go down here, and let's actually look at the Mohegan Tribe. So the tribe we are talking about today is the Mohegan Tribe, and we can open up the map here and see where the Mohegan Tribe is today, or where their reservation is today. As you can see here, we'll zoom out. This is near present day. Let's see if it catches up with us. This is near present day Connecticut, all right? So we're down here in Connecticut, just south of Massachusetts. We see Massachusetts coming around there, and that's sort of like Mashpee, Wampanoag area. We get down here into Narragansett, and we get into the Pequot area. So let's go back. And the Mohegan area. And so let's talk a little bit about the Mohegans. Perhaps you have heard of the Mohegan tribe before. As you can see here, the best way, as always, is to go to a tribe's website to learn about the tribe, right? That makes the most sense. And you can see that they mention that in the early 1600s, there was a lot of change in tribes that are near Connecticut, right? There was pressure from European settlements, and at that time, the Pequot tribe ended up having a separation of some of the chiefs, or what they call the sachems, all right? And so the Pequot, let me go back to this map. The Pequot in the early 1600s controlled a lot of the wampum trade in this area. And I'm sure many of you can recall what wampum is, or you can sort of look at remember the wampum belt of the Haudenosaunee Confederacy or something like that. And so we're sort of a form of currency, right, made out of shells. And what the Pequot would do is they would harvest the wampum in what is the present day called, Long Island Sound by America, or Block Island Sound, right, by these states. They would harvest these shells and this currency, and that currency would be bought by the Dutch down here in the New York area, or the English up in the Boston area, and used for exchange for furs from native peoples closer to the Great Lakes, or that region. And the Pequots had several groups that they were made up of, and they had this grand sachem, okay? And the grand sachem at the time was this guy called Tatobem, in the early 1600s. And he really expanded the Pequot territory, or re-expanded the Pequot territory, until in the early to mid 1600s, the plague came down probably from the Boston area, and killed a number of people, all right? And the Dutch then, who were trading with the Pequot from, who are down in this New York area, then moved in and created a fort, the Fort of Good Hope, I believe it was called, along one of these main river thoroughfares. And that made issues. The English actually created a fort just north of them, and it also made issues with the Pequots. And I think there was some dispute, and the Dutch kidnapped Tatobem, who's the grand sachem of the Pequots, and they held him for ransom. And so the Pequots paid, and they probably paid in wampum, right? And they paid, and then the Dutch killed him anyway. Okay, and so when that happened, there were, let's see here, we can go back here, Sassacus, who was the new Pequot sachem, and Uncas, the sachem of the Mohegans, separated. Okay, and Uncas left with his followers, and they became the Mohegans, or they were, I guess, the Mohegans before, but they separated, and had different, basically formed their own separate governments. They had some separation before, but had come together as Pequots, and then after Tatobem was murdered and the succession went on to Sassacus, there was some disagreement about the way that they were going to interact with settlers or colonizers or whatever, invaders, and these factions split off. All right, so we see here mentions Uncas became the sachem of the Mohegan, and we can kind of see the more information here. So that's how we get this Mohegan tribe, who is the tribe we are looking at today. So let's go back. The Mohegan tribe has a casino, Mohican Sun Casino. You might have heard of it if you were on the East Coast. I'm not sure if they have another casino, but they have at least the Mohegan Sun. We can see it right here on the reservation. Actually, if the camera will catch up, then we might be able to even see it. Oh, there we go. Look at that. Oh, it switched back. All right, there it is. Slowly but surely. There's the casino and there's the river, and we can see that on the map too. And then they have, as you can see, as we zoom out, some off-reservation land. All right, so we get a sense of that, and that's the Mohican Sun Casino. We can take a look at that website and kind of, you can get a sense of what's going on there. Fairly large casino, especially compared to the casinos on Standing Rock. And actually on the map, you can kind of, that's even a better way to do that actually, is let's look at it that way. Again, as you can see, it's almost like a mega mall compared to the casinos out here a little bit. It's a pretty big casino. All right, so I'll go back to this map. The Mohican Sun has, as you might imagine, deals with probably some local hotels, like I think the Hampton Inn is one of them, where they do a free casino shuttle, as you can see there, okay? And they also have, limousines that drive people around other places, and they pick people up probably at the airports, just like you can imagine a big casino might do as part of their business, right? And so we have a gentleman, Mr. Clarke, who was driving a limousine on the state highway in Connecticut off the reservation. I believe it was on 395. I can tell you for sure, I suppose. Or maybe I can't, but in any case, it was on the state highway, so maybe 395. And he rear ends Michelle and Brian Lewis, okay? And there doesn't seem a lot of dispute, and especially for the sake of this case going to the Supreme Court, we can effectively consider him at fault, all right? He has rear-ended, he's driving this limousine for the casino, and he's rear-ended these folks. And let's combine the issues and the procedural holding and actually bring up the case here. which we will go through a little bit. But I wanted to start out by noting that you probably have seen in these cases this section of the case called the syllabus, right? And the syllabus usually appears at the beginning here, before the main opinion. It's not part of the opinion. It's the court reporter adds, and the court reporters change, but the court reporter adds this syllabus to help people who are reading the case to understand more quickly or better understand the decision. All right. Usually it discusses the facts of the case and the path that the case has taken in order to get to the US Supreme Court. And so if you don't have enough time to say read a long opinion, say it's a 15-page opinion, looking at the syllabus is a good way to get a sense of the case. That being said, a syllabus constitutes no part of the opinion of the court, all right? That it has been prepared by the reporter of decisions for the convenience of the reader, as this case mentioned. And they actually had this case where they looked to the syllabus, or they looked to the head notes and tried to say that those head notes were authority, that they were precedential, and in fact, the court ruled that no. The syllabus or the head notes itself isn't precedential. So although you can read the syllabus, and it might give you a good idea, don't take it as established law necessarily. Instead, if you want to quote something, or if you want to, consider some language precedential, you'll have to get that from the opinion, which can usually be found after it. I'll note too that if you've been in law libraries or in the offices of attorneys, you'll probably see these volumes of books on the walls, and bookcases, I suppose. And these are the Supreme Court reporters, all right? This is the collection of Supreme Court cases, which includes the citations and other information. So just like you all know that you can go to OYA or wherever else to find case briefs if you don't have a lot of time to read through a case. Not these cases, you should be trying to, I guess, attempt to read through these cases. But if you happen to hear a case in the future and you're interested in finding out more about it or whatever, you can look at a case brief, but you can also look at the beginning of the case and if they've included the syllabus. So let's look at the syllabus for this case and see what we can discern right off the bat. We see petitioners Brian and Michelle Lewis, right? We see that they're driving on the Connecticut Interstate. Interstate is a word that they use more frequently in other parts of the US for these big highways that go between states. Here in the Dakotas, or in the states of North and South Dakota, the interstates are more rare and less big, but they frequently also have tolls and toll booths on the East Coast and in other places. So that's not something that is the case here. Anyway, so William Clarke was a Mohegan Tribal Gaming Authority employee. He was driving this limousine transporting Mohican Sun Casino patrons. And the Lewises sue Clarke in his individual capacity, all right? In his individual capacity, keep note of that because we'll come back to it. In state court, state of Connecticut, Clarke moves to dismiss for lack of subject matter jurisdiction, saying that he's an employee of the Mohegan Tribe's gaming authority, and therefore he's entitled to their sovereign immunity. We've talked a lot about what sovereign immunity is, so you all probably have a good idea about that. And he says he's acting within the scope of his employment. He argues in the alternative, and in the alternative basically means like, if the first argument fails, I'd like to propose the second argument, but I'm not discounting one or the other. So, if I make this argument, I'm not, what they call is like, use it or lose it. So you want to try to make these arguments instead of potentially losing them further down the line or waiving them and not claiming them. So he says otherwise that if he should prevail because the that he should prevail because he had signed this indemnification clause, or there was an indemnification clause in his contract with the gaming authority, and therefore they were bound by a tribal law to indemnify him. Indemnify just means step in and almost like take the, not quite take the blame for, but uh, protect. Similar almost a little bit to sort of providing this immunity, except it isn't like this blanket thing. If your insurance company, for example, indemnifies you, all right, against large losses or something potentially. All right, so the trial court denies his motion. The Supreme Court reverses, the Supreme Court of Connecticut reverses and says that tribal sovereign immunity bars the suit. Let's start to put some of this down, and you can write this down just as simply as I wrote it down here, just working your way through this syllabus, all right? So if you get to a case and, for example, if it's an extremely long case and you're, it's just too much to comprehend, or if you need to even look at, say, the syllabus or a case brief in the beginning to begin to understand what's occurring in the case, therefore making your reading of the opinion more useful, right? More, you can already understand what's going on. So then you can actually get more out of the opinion. A good way to do it is really just start sentence by sentence, take this apart, break it down. So we've got these petitioners, they're driving. William Clarke is driving this limousine. He hits them from behind. He's happens to be driving, we find out later in the opinion, on off the reservation, right? And he's on state land. So the Lewises sue Clarke in his individual capacity, and that was in the syllabus there that we just read. And he moves to dismiss, right? And on one side, he says their sovereign immunity should protect him. And on the other side, he says the gaming authority should be bound to indemnify him, all right? And the trial court denies it. And later on, we find out that a voluntary undertaking cannot be used to extend sovereign immunity where it did not exist otherwise. And then we see that so a voluntary undertaking cannot be used to extend sovereign immunity where it did not exist otherwise, or did not otherwise exist. That basically means that we'll come back to it, all right? But that is the reason why, and it's because of this individual capacity. So just kind of keep that in the back of your mind for now. The case goes from the state trial court in Connecticut to the Connecticut Supreme Court. I'm not sure why it makes that jump. Maybe there's either no appellate court, or sometimes in some of these eastern states, they actually call, like they call the superior court their appellate court, but I don't think that's the case here. Or there must be something that allows it to go right to the Connecticut Supreme Court. All right, it ends up there. They reverse it, and they hold that, in fact, tribal sovereign immunity does bar the suit, because they say he was acting within the scope of his employment when the accident occurred, and they didn't consider whether Clarke should be entitled to sovereign immunity based on the indemnification statute. So almost all of this here we have gotten from one paragraph at the beginning of the syllabus, all right? So, if you haven't done this yet, for one of these cases, before you watch the video, when you've got the case, take a look at it, try reading just the first couple paragraphs or the first paragraph of the syllabus, and try either diagramming it or making notes on it. And you can do some sort of chart where you use arrows to interconnect things like I like to do, or however you'd like to do it. But you can really break word by word apart, sentence by sentence apart, and use that as an opportunity to see how much of it you're understanding, and then watch, say, for example, this video to get more information and to see if you were on track, okay? Or come to the discussion group. A great reason to come to the discussion group and share what you learned when you were diagramming this part of the syllabus and just getting into the case like that. So we see here there's actually a video you can watch if you go to the Connecticut, their public media station, I think, their public TV. I think that's what this is, Connecticut Network. And you can actually watch, you've got the URL right there. You can watch this case being argued in the Connecticut Supreme Court. Look at this very exciting buildup, right? Not the same as Oyez, not cutting to the chase with their Oyez, but we've got kind of a programming thing here. Let me skip ahead though. And so we can see.
Your Honors, the issue in this appeal is the trial court's improper conclusion that tribal sovereign immunity does not bar a suit against a tribal employee for actions that are undisputedly in the course and scope of his employment if the plaintiff chooses to label that suit an individual capacity suit.
All right, so right there, right off the bat, we heard Mr. Clarke's attorney saying that, let me go back to him. Mr. Clarke's attorney saying that this idea of personal individual capacity, if you sue someone and you say that it's in their individual capacity, that is not a way to get around tribal sovereign immunity. All right, so we hear him say that right off the bat, and that is what one of the issues in this case becomes. But I think that these are sort of interesting arguments to watch. So feel free to, come back to this on your own. On this side, we've got the attorney for the non-tribal members, or I assume they're non-tribal, but maybe I shouldn't make assumptions like that. But we've got James Harrington, who's the attorney for Brian and Michelle Lewis, right? All right, so we've looked at the syllabus. Let me see here. And we've diagrammed it a little bit. We understand our parties. And then let's look now at the opinion. All right, let me see where we're going here. All right, and actually, before we even get deeper into that, I'm going to talk a little bit about the applicable law. And it's important sometimes to look for this applicable law. And so actually, let's go straight to the Mohegan Tribal Code. And for Standing Rock, you can find the tribal code, the most recent tribal code, I believe, on the standingrock.org website. For Cheyenne River, it might be the same, I'm not sure, although I'm not sure if Cheyenne River's code is up there. But if you're looking for a tribal code, and let's be clear here, when we're talking about code in a legal context, we're generally talking about a body of law, all right? So a criminal code or a civil code. States have these, the federal government has its laws, right? And then tribes also have tribal codes. And this is how tribes collect their laws if they choose to do it in that format. Many do. And NARF, which we've talked about before, the Native American Rights Fund, has this National Indian Law Library where actually they've gathered many of tribal codes. Tribes send in their codes to NARF, okay? This is something tribes choose to do so that they can share with other tribes and with whoever else their codes. So here we see the Mohegan Indian Tribe of Connecticut, and we can actually look through the different parts of it, right? A long code, and you can see that there's a piece on the Council of Elders ordinances and resolution, right? And then there's also this Tribal Gaming Authority ordinances and resolutions. So it just happens that the Mohegan Constitution and the Mohegan Tribal Code lays out its sovereign immunity, all right, and indemnification policies applicable to disputes from gaming activities. This is part of when states create those compacts with tribes, or tribes create those compacts with states. Frequently, they include certain waivers of sovereign immunity. That might be something that the state waives as well, right? And in this tribal code, the Mohegan's tribal code, the Gaming Authority has waived its sovereign immunity and consented to be sued in Mohegan Gaming Disputes Court. So that is a way to, you might question, why would the Mohegan Gaming Authority agree to be sued in any court if they don't have to, right? Why would they waive their sovereign immunity? Well, this might be something that they offer up. They might, when they're in these contracting or these compacting agreements with the states, they may say, look, in certain instances, we're willing to waive this. And vice versa, the states may say, well, in certain instances, we're willing to waive this. Because remember, states have this different immunity, but it's similar in some aspects. And actually, in this case, the US Supreme Court really notes tribal sovereign immunity as being a lot closer to state sovereign immunity, which in other cases it has not. Or it suggests that it is. It offers a lot of parallels to state sovereign immunity arguments in the opinion, as you'll see. But it's actually a position of strength to be able to consent to waive sovereign immunity at certain times, whether that be for a state or for a tribe. And so they've agreed to be sued, and they've designated the venue, right? They've agreed to be sued in Mohegan Gaming Disputes Court, which I'm sure you can find more information on online. Also in the Constitution, the Tribal Code, and in this case, this US Supreme Court case, it's noted that tribes do not surrender their immunity against suits by states, okay? And the tribes, in this case, the Mohegan Tribe and the Gaming Authority have not consented to be sued for claims arising under Connecticut state law. All right, so right off the bat, that's in there as well. But Mohegan law also says that the Gaming Authority shall indemnify its officer or employee from financial loss by reason of his or her negligence if the officer employee is found to have been acting in the discharge of his or her duties, so basically while doing their duties within the scope of his or her employment. And it goes on to say that it does not indemnify employees who engage in wanton, reckless, or malicious activity. All right, and so we didn't talk too much about the actual circumstances of Mr. Clarke running into the back of the Lewis's car, but the court has held that he certainly maybe did it, okay, and maybe there was some reckless behavior going on there. All right, I won't say for sure one way or another, but that might have been the case. Okay, and so if we look first at, so we've got the facts of this case. We've got we understand what happened. We know where we are. We recognize that this is an incident which occurred off the reservation, right, and not on even the off-reservation trust lands, but on the state highway. So we're in the jurisdiction probably of the state, we might assume, but I think it's still worth looking to the tribal law here, because if this is a dispute related to the gaming operations, it's going to have to be brought through this gaming disputes court, right? That's what's been agreed to by the Tribal Gaming Authority, and so this it's still worth looking to the Mohegan Tribal Code, and then also just to understand what the Gaming Authority has agreed to indemnify, for example, or the scope of the tribe's sovereign immunity as the tribe has defined it. I know in your first assignment, there was one of you who suggested that Standing Rock needs to have a clear statement of its own sovereign immunity. We had looked at some other tribes, and some of them had these statements of sovereign immunity on their website. And one of you mentioned that that was not the case for Standing Rock, and I don't remember if I checked that out. But certainly that's something, maybe that we consider. But all right, so we have the facts, and now we've gone in search of, say we were just looking into this on our own, we've gone in search of some of the laws that might be applicable. So if we get into the opinion here, we can see that Justice Sotomayor, who is the author of the opinion, and actually we were already in there, weren't we? Twice, in fact. And when we look at the opinion, we can see it says opinion of the court, right? It's below the syllabus, and we see Justice Sotomayor is the one delivering it. And we see her suggest pretty early on that there are two main issues here. So she goes into a little bit of the history of the Mohegans, actually, and talks a little bit about them entering into a gaming compact with the state of Connecticut, all right? And she talks about, and representing the court, talk about the sovereign immunity and indemnification policies that are applicable within that scope of the gaming authority, okay? And goes on to talk again, a limousine driven by William Clarke hit their vehicle from behind. All right, for the purposes of this appeal, as I had mentioned, it's undisputed that Clarke caused the accident. All right, so we get in further here and we'll get into two issues. All right, so let's just pull those issues out and look at them here. We've got issue 1, whether the sovereign immunity of an Indian tribe bars individual capacity damages against tribal employees for torts committed within the scope of their employment. Let's break that down for a second. Whether the sovereign immunity, we know what sovereign immunity is, okay, of an Indian tribe, all right, sovereign immunity of an Indian tribe, bars, so stops or prevents or precludes or whatever, individual capacity damages, right, against tribal employees for torts. We know torts means civil law, right? It means wrongs that are remedied through civil law, through suing another party, as opposed to generally through, say, a prosecutor bringing charges that are criminal, right? So for torts, for offenses against another person, for example, where you're suing that person committed within the scope of their employment, all right? So for torts committed within the suit of their employment. That's our first issue. Our second issue is what role, if any, a tribe's decision to indemnify its employees plays in this analysis. And the analysis we're talking about here is the sovereign immunity analysis, okay? So let's begin by looking at this individual capacity bit. And I have a kind of a note here: is the tribe the real party? And courts may not simply rely on the characterization of the party. So for example, we had just heard when we listened to the attorney for Mr. Clarke, he argued that, you know, as you recall from a second ago, you can rewind to the video, that, you know, maybe using individual capacity or suing people as their persons was a way to circumvent sovereign immunity, and he was arguing that people shouldn't be allowed to do that, and that was applicable in this case. Well, the Supreme Court is saying here that, okay, so yes, the Mr. Clarke has characterized it that way, and his attorney. When we say Mr. Clarke, we're generally referring to what his attorney says as well, and we refer to that as Mr. Clarke as well. So we can't simply listen to what he's saying necessarily, but the court actually needs to determine in the first instance, which just means they need to determine themselves whether or not the remedy sought is truly against the sovereign. Who's the sovereign in this case? Yes, the Mohegan Tribe, right? That is the big sovereign in this case. And if so, if the tribe is the real party, if so, sovereign immunity bars the suit. But let us look at this real party question. So the real party in interest, and I'm not going to get into it, but driving offenses in particular they're frequently litigated, right? There's a lot of civil law, there are a lot of tort suits that are brought about driving offenses. And you'll recall that we've talked about vicarious liability. We talked about that in the Dollar General case, right? How in that case, Dollar General was vicariously liable for the actions of their store manager when it failed to supervise him, and allowed, these things to happen to this young boy. And in this case, is there some sort of vicarious liability applying here? Although we wouldn't use those exact words, but who is the party in interest? So we've got Mr. Clarke, and he's acting In the scope of his employment, sure, right? He's driving the car. It's the car for the casino, the limousine. He probably wouldn't be driving it if it wasn't for his job. He probably shouldn't be driving it if it wasn't for his job. But that's the only fact that sort of implicates the tribe in any way, okay? And so he's not on tribal land, X, Y, and Z, all right? So maybe if there are other factors, and the Supreme Court leaves that open, they say that fact on its own um, was not enough, right? Was not sufficient. But potentially, if there were other factors, you know, maybe he would have not have necessarily been the real party. But here, it's him. He's driving. He's maybe driving recklessly, and because sovereign immunity doesn't apply, the tribe sovereign immunity doesn't apply, and we'll talk more about that in a second. The indemnification provision doesn't, and so he doesn't have this sovereign immunity. And the tribe, on the other hand, if they were the real party in interest, which my red crossed out line here means to suggest that they're not, right? If the tribe was the real party in interest, it would have sovereign immunity. So how do we determine this real party in interest and if this sovereign immunity applies? I've got a couple questions here that are actually directly pulled from this opinion, and let's just talk about them for a sec. If the relief is the relief sought nominally, so nominally means just minimally, okay, nominally against the official, and if the answer is no, then it's in the individual's capacity, like the individual capacity as opposed to the official capacity. Let me talk, actually, I didn't go over individual capacity and official capacity enough. Basically, in the law, individual capacity means it's what they call a term of art, okay? And a term of art is just like words that are used specific ways in a discipline or a field, and in this case, words that are used specific ways in the law. So when we talk about, civil, for example, when we talk about civil in the law, we're talking about civil jurisdiction. We're not necessarily meaning like behaving civilly, like using, whatever, your salad fork or something, or meaning this sort of term of art is how we're using this word civil in the law almost. And so, and you know about civil jurisdiction and civil, we just talked about civil law and torts and things. So you can kind of see how that would be. But individual capacity in the law means basically your status as a person and going to your personal role, all right? Not going to your role as a employee, not going to your role as a part of an organization, a board member, whatever else, but in your individual capacity. So if you were acting in your individual capacity, you wouldn't be acting, you'd be acting for your own reasons. And you wouldn't be acting as part of your organization or as an agent of your corporation or whatever. So when an individual is acting in individual capacity, their actions will not generally incur any liability on behalf of their employer. All right. So if you are suing someone in their individual capacity, you're not suing their employer, for instance, you're suing them. And alternately, so there isn't basically like corporate liability or some sort of vicarious liability or something. It's the individual's fault, is what is the case in such instances. And as opposed to, say, their official capacity. In their official capacity, they wouldn't have protection from their protection, as an individual. They'd have protection as part of whatever group they were an officer for or an employee of. Okay, so yeah, so I hope that helps a little bit. We can talk more about that, but let's look at some of the questions pulled right from the case. And these are questions that, if we go through this case, we can kind of look at like each of these. They really try to make these cases easy to read. And, when you're breaking it down in your notes, you can actually use these same subject headings that Justice Sotomayor has used here. And you can differentiate your notes that way, or not, I suppose not to differentiate, it's not a great word for that, but you can otherwise split up your notes into these clean areas based on how Justice Sotomayor has done it, or you can just make some sort of free-for-all big chart where you connect things if you're going to go through the whole case like that, but that's a lot. So is the relief sought nominally against the official? So in this instance, we've got William Clarke driving this car, and he maybe just rams it into the back of the Lewises, okay? And the Lewises sue him. Is it just a teeny bit his fault, like not really his fault? Is it mostly the casino's fault, or is it a good amount his fault, or at least half of it or something his fault? We might say here that no, it's not nominally, it's not minimally against the official. Like maybe Mr. Clarke is really has some stake in this, or maybe he really should answer something. So that would go toward this individual capacity. Is the relief sought in fact against the official's office and thus the sovereign itself? So are Brian and Michelle Lewis actually seeking something from the Mohegan Tribe, not Mr. Clarke? And we can kind of denote by the way they filed this suit, they filed it as against him, right? They didn't file a suit against the Mohegan Tribe. That would have been a different suit. We wouldn't maybe have been in this situation, but they filed it against him, okay? And if they had filed it against the Mohegan Tribe, what would have happened? The Mohegan Tribe probably would have claimed its sovereign immunity, right? Because it would have been clearly against them. Or alternatively, they might have suggested, in fact, this is not the way you should do this. You should do this as a personal capacity, individual capacity lawsuit against Mr. Clarke or whatever. But in this case, is the relief sought one against the official's office? I think we can look at this case and we can maybe say no, that they're seeking damages or whatever from Mr. Clarke himself. So that would point toward individual capacity. Does it require action by a sovereign or disturb the property of the sovereign? The Lewises haven't filed suit against the Mohegan Tribe, right? So the Mohegan Tribe doesn't have to respond. And unlike in other cases, like for example, the Dollar General case, right, where the Mississippi Band of Choctaw stepped in on behalf of the child, unlike in that case, it doesn't require any action by the sovereign. The Lewises didn't sue Mohegan. Mohegan doesn't have to step in for some reason, it appears, right? Or disturb the sovereign's property. Although, and I will note that I'm saying that, but actually Mohegan has a stake in this, right? And Mohegan, their attorneys actually do take part in some of this lawsuit. That being said, though, does it require action? You could sort of argue no. Or does it disturb the sovereign's property? Well, the car the limousine is probably the sovereign's property, right? That's the Mohegan Tribe's property. Does it disturb it? Sure, but in that case, you'd want that'd be the Mohegan Tribe who would actually want to sue Mr. Clarke, right? Or if Mr. Clarke was suing the Mohegan Tribe about the car, or about the limousine. But in this case, it's the Lewises, and they're probably not looking for damages for the limousine. They're probably looking for the damages for their own car, for themselves, right? So does it disturb the sovereign's property? Maybe no. We can maybe argue no for that one. And so that might point toward individual capacity too. And then the sort of last question, is the party functioning as a fiscal intermediary or otherwise? And I note that in there because the case actually mentions examples where fiscal intermediaries are basically effectively state instrumentalities. State instrumentalities means that they are acting on behalf of the state or effectively as part of the state, even if they're not an actual state entity. All right. And we see this here that, and there are other cases that do say that if that's the case, then you might bring suit against the official in the official capacity or whatever. And we see that's probably not the case here either. So in individual capacity suits, personal capacity suits seek to impose individual liability upon a government officer. This is from another case for actions taken under the color of state law. So that's just an example from another case. And then official capacity alternately Official capacity is when officials have been sued in their official capacities. And for example, if they leave office, their successors, the people who come after them automatically assume their role in the litigation. Now, an example of this would be, I don't know if we've dealt with a case that has named a governor in its suit. I don't think we have, but, or, it might have at the trial level and that name might have just gotten dropped or I might have ignored it. But sometimes when tribes bring suit against a state, they will bring suit against the named governor of that state. And that's a pretty common way to bring suit against a state is you name their chief executive officer, okay? So if you brought suit against the governor of, say, North Dakota or South Dakota, say you brought suit against the governor of South Dakota, Kristi Noem right now, and she left office. Well, if you were bringing suit against the state, and if it wasn't against her personally, when she left office, that suit would then go on to the next person who became the governor. All right, so that wouldn't follow her home necessarily unless it was a personal suit against her or something, in particular with her. But if it was just about suing the state of South Dakota and you were naming her, then it would continue on to the next person. So their successor would automatically assume their role in the litigation. All right. So in Lewis versus Clarke, we can see how the court found the answers to all these questions to be no, and therefore Mr. Clarke was acting in his individual capacity. And again, there's a whole history of litigation which has to do with people driving cars, and when people drive cars, say recklessly or dangerously, who's at fault, and generally it's the driver. Okay. All right, so we've got our rule and our holding. Does tribal sovereign immunity block this type of suit? No. Tribal sovereign immunity would block a suit if it was, someone being sued in their official capacity. In this instance, we've got someone being sued in their individual capacity. Mr. Clarke is not being sued sort of on behalf of the tribe. He's being sued as an individual person. Okay, so tribal sovereign immunity. No tribal sovereign immunity if the employee of a tribe is operating in a non-discretionary individual capacity, but then also no using suits against officers to circumvent tribal sovereign immunity. It's the same type of sovereign immunity. In this case, the court sort of suggests there's an equivalency between state sovereign immunity and federal sovereign immunity. The court didn't talk about, Justice Sotomayor in this opinion doesn't talk about issues of whether or not Mr. Clarke might have had official immunity and whether or not that would prevent suit, right? And we can sort of suspect that yes, that would prevent suit because you'd effectively just be suing the tribe, right? So we can take away this idea of this. I use the word comedy here. What comedy basically means is this sort of mutual behavior. The state does it this way, the tribe does it this way, and they choose to respect, or I guess not necessarily respect, but agree to, for example, during compacting, whether you have like a law enforcement compact where states and tribes agree to do this, or if, say, in these gaming compacts, they're agreeing to, trade this for this or whatever. And comedy is sort of this broader idea of both sovereigns agreeing on things that are to their mutual benefit, let's say. And so tribes and states sometimes can work together on tort claims acts, all right? And they can work together particularly on waivers of immunity for personal capacity suits, all right? So if, for example, a tribe has a tort claims act or a type of basically a section within its code, which it might call whatever, right, but is effectively similar to what a torts claims act is. If a tribe, for example, has a piece like that in its code, a state may want to grant that kind of, or maybe not grant it comedy, but kind of show comedy by also including in its state code a similar procedure. And so In a Torts Claims Act, you may have a suggestion, not a suggestion, but you may have a procedure for how to handle certain type of damage claims, monetary damage claims, if there's loss of property or if there's some sort of personal injury or something. All right. And say the tribe has this law and the state thinks, okay, this is a good idea, and the state does that too. And then there's this comedy. And also, if you're going to agree to something like that, it could be the other way around too. It could be that the state has this Torts Claims Act and the tribe decides that it wants to go by the same kind of rules as the state, especially in regards to this waiver of immunity for personal capacity suits. So the tribe could say, look, if this was a suit being brought against someone in a personal capacity, we are going to waive our sovereign immunity. And like we talked about in the beginning, by stepping up and writing that into their tribal code or whatever, that is basically, even though you're agreeing to waive sovereign immunity, you are the one making that choice, right? And so a tribe could include that within its tribal code. It could include it to match the states, or the state could include it to match the tribes, and make it clear that in those instances, so whether or not someone tried to bring an action in tribal court or in state court or whatever, the result might be the same. And tribes could choose to do that or not. But and there's a whole thing, federal common law still provides immunity for discretionary acts, and common law does apply to all acts under official capacity. So this idea of if you're acting within your official capacity, then the immunity, if it's for a government, for example, of that government, the sovereign immunity might apply, whether that be the state type of sovereign immunity or the tribal type of sovereign immunity. All right, so, oh wait, that's just a copy of the syllabus, I guess. There are many additional resources on this case. I know we've got some people in this class who work for tribes right now. And so this might be something you've thought about, as someone who works for a tribe, and actually many of you likely have worked for tribes, right? And you might think to yourself, like, if I'm operating in my official capacity or if I'm operating in my personal capacity, and what are the differences there? And also, if the tribe has agreed to indemnify me, do I first need to be either working in my individual capacity, or does sovereign immunity need to apply otherwise first in order for that indemnity to kind of hold up, right? Something like that. So there's some other resources I can point you towards. I haven't read through all of these, so gosh knows whether they're questionable or not. So take it with a grain of salt, but there's some resources, and you can just, I'm sure you can easily just pull out some of this language and Google it if that's of interest to you. What I might recommend, though, especially for those people who work for tribes, is to listen to a little bit of this NCAI, National Congress of American Indians, webinar, where they teamed up with many of the attorneys, and then also, I believe, the U.S. Supreme Court, or the Tribal Supreme Court Project, which we've talked about, which is part of that Native American Rights Fund, Tribal Supreme Court Project, which we had attorneys on in our previous tribal sovereignty discussion groups. We actually have had an attorney from NARF's Tribal Supreme Court Project on there discussing that project with us. So if you go to YouTube, you can type in Lewis versus Clarke, and you might put it in quotation marks to give you this exact result. Remember that Clarke in this case is spelled with an E. And you can look at that. And this is a great webinar, and it actually goes through after this decision, and you can kind of see how these things operate. So when this decision came out, the tribes, beginning with the Mohegans, but then other tribes, and then also the insurers for the tribes. Now, why would the insurers for the tribes care? The insurers for the tribes are the ones who are going to be paying out if the tribe is somehow at fault and its sovereign immunity hasn't applied, or if it has agreed to a waiver, right? If it has agreed to this in, for example, going to gaming court. And why might tribes agree to that? Because that might be part of their compacts, or because they might just decide that that's the right thing to do, or whatever. It might just be the tribe's way of providing a recourse for people who, for example, slip and fall at their casinos or whatever else, to go through this process where the tribe can, the tribe may and their insurance company may pay out or whatever if found in favor of whoever the plaintiff is. So I think this is pretty interesting if you haven't heard something like this before, and I'm going to recommend it, especially for those of you who do happen to work for a tribe right now, um, and are wondering about, maybe your individual capacity or whatever, or are looking for ways to strengthen the tribal code or tribal practices to prevent someone, for example, either circumventing the whole process by trying to claim something that isn't the case, or by making those forward steps and saying, like, look, in these instances we are agreeing to a limited waiver of sovereign immunity for personal capacity suits, and we are going to align this with the state's tort claims act, or we're going to lobby the state to have them align it with ours. Okay. So this is something that might be good to check out. But with that, I will see everyone for our tribal sovereignty discussion group at 4:30 on Wednesday. And we will have some discussion group questions at that point. And I wish you all a great week. Welcome back. And I'll see you Wednesday.